Yeah, absolutely. And I mean, it's a great thing to discuss because some of this isn't entirely intuitive. Some of it very much is, but not all of it. Um, so at the highest level, there is viewpoint discrimination, which is impermissible everywhere. The government is not permitted to engage in viewpoint discrimination, no matter the circumstances. Particularly when we're talking about traditional public forum where First Amendment rights are at their highest, you could say that if they engage in it there, it's particularly bad, but they can't do it anywhere. And so, we don't want the government putting their thumb on the scales effectively and saying, okay, well, we like this viewpoint, we don't like this viewpoint. And what this includes, and this is the part that I think is probably less intuitive to some people, is the Supreme Court has been very clear that giving offense is a viewpoint. And so if the government is silencing speech, which, as we described, doesn't have to be words, it can be images, ideas, any kind of expression, because it finds it offensive or inappropriate, that is impermissible viewpoint discrimination. There has to be another rationale behind it. And so here, what you see in the videos is them explaining repeatedly that the sole reason why they're doing this, why they're shutting down debauch and ferocious speech, is because they find it offensive and they're concerned that other people will find it offensive. That's classic viewpoint discrimination. And again, we've got, ample Supreme Court law and Fifth Circuit precedent that supports that. And then, aside from viewpoint-based discrimination, as we've already described, this is a content-based prohibition as well. So the Supreme Court has said that, the paradigmatic example of content-based discrimination is when it targets particular subject matter or particular topic for disparate treatment, regardless of whether it takes any stance on that subject matter, any stance on viewpoint. So something that the defendants argue at length is that, well, this can't be content-based because we're not taking a position on the content, and that's just not what content-based discrimination is. What they're doing is they're targeting images that, in their characterization, depict cruelty and violence towards animals. That's classic content-based discrimination. And so where you have content-based discrimination, you have to satisfy strict scrutiny. What they're arguing is that this is not viewpoint-based, it's not content-based, this is simply a time, place, manner restriction. But the time, place, manner restriction presupposes content neutrality, and their brief. It's something you see a lot in these cases where they sort of breeze past, the fact that this prohibition is content based on its face and simply say, oh, no, we're simply trying to limit, the manner, the location, the time, the place, the manner, those sorts of things. But again, time, place, and manner presupposes content neutrality. So where it's content based, you're not going to apply the same kind of lower threshold as you would in a content neutral time, place, manner restriction.
It's interesting because they've never actually, the time that we're allowed to do this is never, and the place that our clients are allowed to do this is nowhere within Discovery Green. And as to the manner, they don't have a rule that says no videos. That's not a rule that's in the park. And one of the doctrines of First Amendment is that the grounds that the government gives at the time is what they have to stick by in court, because otherwise it encourages bad faith and bad actors. So they didn't give a time, manner, place restriction at the time of the arrest, so they aren't allowed to create a new one now.
And just to clarify one thing, if they were to say, going forward, we are not going to permit video footage to be displayed in the park, that would be content neutral. And then it would be subject to a different analysis.
Right. That's a whole other case.
Exactly.
Not necessarily okay, but that's not what we're talking about.
Right. Exactly. The question of whether or not that's going to be acceptable, but we'd have to answer that separately. But it is a different analysis. It's a lower bar. But here, at no point do they say, oh, well, we don't permit video footage, as John said. I mean, the issue, as they described it over and over and over, was that they found the content offensive.
So they said in their brief, I think, that this would allow people to show videos of tortured children in a playground. How do you respond to that?
So, again, if they had a speech prohibition in place that says we do not permit video footage of children being tortured, that is a content-based restriction. And so it would need to satisfy strict scrutiny, which, law students listening, former attorneys are going to know, you've got to show that there's a compelling government interest that's narrowly tailored. And it's a very high bar. But, for all we know, something like that would pass strict scrutiny.
Yeah.
Certainly if there are lots of playgrounds around, I mean, it's, it certainly could pass strict scrutiny. But if the prohibition were broader and simply said, we're not going to permit any kind of video footage, we're not going to, let's say we're not going to permit any expressive activity, within a certain radius around playgrounds, things like that, those are content neutral, and so they're subject to a lower bar. So again, and John made this great point earlier that no one would suggest that the government is not able to regulate expression in traditional public forums. They're able to, but we do have these frameworks in place for good reason.
And I would also note that this is something Sara made a great point during our oral argument. We don't call this torture in our briefs, and Darius and Faraz don't call this torture. They don't call it animal cruelty. They just say, this is what happens to these animals. It's only the defendant that's calling it torture to animals. So it's interesting that they give it that kind of moral valence. And when it comes to images of, like dead children, I mean, perhaps the most iconic image of the Vietnam War was a naked child being napalmed. And some of the most powerful images of the war in Gaza are images of dead children. So the idea that the government on a purely political topic could censor those powerful images, I'm also dubious of that. At the playground, I can concede, but in an entire park, it's those powerful images that move the heart.
Absolutely. I mean, and as I said before, in animal rights, I think that's more true than people know they care about children, but sometimes people don't even know they care about chickens until they see a chicken being tortured, and then they realize, oh my God, this is wrong. And until then, it was a joke, and then all of a sudden, it's not a joke.
Yeah, I would note that one area that there's not precedent on this finding in the Fifth Circuit, but it's probably a very similar issue, is that a lot of anti-abortion protesters show images and photos of aborted fetuses for the same justification.
Exactly.
And as those cases have shown up in other circuits, I think every other circuit has said you cannot ban those images just because they disturb people.
So I think that you also mentioned, which I think is that these actions constituted prior restraint. I mean, we're running out of time, but can you briefly explain that? Because that seems like a particularly important point, because that's a really, really powerful pair of words in First Amendment jurisprudence, right? Prior restraint.
Yeah, so you're absolutely right. The prior restraints, these are, considered to be the most, insidious type of speech prohibition. And these are, as the name suggests, these are prohibitions that kind of go in place in advance, ahead of when the expression is to occur. And here we have one that, it's particularly problematic for at least two reasons. One, it's taking place in a traditional public forum. And two, it's subject to the, unbridled discretion of the Conservancy president and Conservancy staff. So, we spoke earlier about how, John and his clinic drafted the letter to the Conservancy and the city and the Park Corporation, pursuant to the Texas Religious and Freedom Act, kind of laying out all of the bases for our claims in this case. Setting forth the religious motivation, but not just that, all of the free speech claims as well. And the Conservancy came back and said, our position has not changed. They're not going to be permitted to show this, muted documentary footage. And so, our argument is that operates as a prior restraint. It's been in place since then, since the letter was sent in May 2023. And it's, particularly problematic for the reasons that I described.
Yeah, I think that's a powerful argument.